the court to consider. My lord, is the registrar. The registrar. Now, if the applicant does not file a single case within a time stipulated under Sub 2, the registrar shall certify that fact to the court, which may dismiss the application for non-prosecution or make such other order as it may consider appropriate. There is nowhere, my lord, that the non-filing, the statement of case, deprive the court of jurisdiction to detain the application that was before it, to the extent that the registrar or the court, which was supposed, if it was desired to do so, made no such order. In any event, my lord, the respondent, that is the EC, that was supposed to go and carry on constitution, did not put application. They took the view that yes, they wanted to go and do their work. And indeed, my lords, they have gone to do their work, declare the winner, declare the loser, and the matter is foreclosed.
Oh,
foreclosed.
If that were the law, the illegality will persist forever.
My lords,
so I'd like your other arguments, but as for foreclose,
my lords,
your other arguments you have answered substantive.
My lords,
yeah.
My lords, an order by a court to proceed to perform a constitutional essential function.
If it's set aside, that would be the consequences are clear in the authorities. Anyway,
with respect.
Yeah. Your other points I will take, but as for this one.
Yes.
Yeah.
Further, my lords. It is not the applicants that were going to perform the said constitutional duty. Not the applicants. It's the first interested party. So granted, which I already indicated that the joint application was not funded by the rules. Granted, there will not have been a necessary party to the action. Granted, because the application was directed at a specific body, the EC, and no one else.
Now let me pick your mind on something the trial judge said in the ruling by Nana Equia Owusu Afriye. If one of your assistants can open to that. The ruling in respect of the application by Nana Equia Owusu. Yeah, be serious. Now, if you can read the whole of paragraph 1 and it extends to the next page, read it and.
Paragraph 1.
Yes.
As we be serious, the application on the face of it is not different, not a court in the person of Godwin Edugi Kujo Tamaklu, to the effect that the winner of this constituency has been declared, and which has no evidence is before this court, except an application yet to be moved. It is observation of this court that the respondent will not be affected if indeed it has been declared already.
Now you stop.
As it stands.
No, just now you stop there. You see, this conditional, if it has been declared already, where does it leave us? Because the applicants are contending that it was declared already. And then She's saying that if it has been declared already, then this ruling doesn't change. I'm finding it difficult.
Alos. Alos.
Yeah, you were there, so probably you.
Yes, Alos. The application might have been far before you. If you look at all the exhibits which they have filed, my Lord should realize, what is all this? My Lord should realize that they have not, or they did not. What is this? They did not. No, our application. Our what is it? Yes, they did not attach any parliamentary election results summary sheet to demonstrate that, in fact and indeed.
Oh, that we hadn't reached that stage. And because
then direct me properly.
No, the point I'm making is that the judge is saying that if there had been a declaration already, then the person whom it was first declared for would not be affected by this ruling. But that is a very risky, slippery ground.
My Lord, the bottom line is that, let's say, even there was even a declaration, in quote, but there was none, in quote. If the collation is done and you won, it will be confirmed that indeed you have won.
No. The judge said it will not affect her.
No.
Anyway, it is not your writing. It's because you were there. That's why I wanted you to react.
There is no way that if you win an election and you have won an election, the results will change. If you have won, you have won. If you have lost, you have lost.
Anyway, that is the dispute. The dispute is whether the first person won or the second person. So that's the dispute. But I must be honest with you that the application before us, we are not in a position to resolve the factual dispute.
That is true.
As to whether the person who was first declared or the person who was second declared. We are not in a position to resolve that dispute. Ours is to look at the legality of the proceedings that resulted in the order for the Electoral Commission.
Yes.
Yeah, so wind up and then.
So, my Lord, in conclusion, I submit that another High Court judge was acting within a jurisdiction there is no error of law patent on the face of the record. Which errors goes into jurisdiction, which is so plain to manifest a nullity. There was no breach of natural justice. So, my lords, we submit forcefully that the High Court judge exercise a discretion. If the applicants are agreed about the discretion so exercised by any High Court judge, their remedy lies in an appeal. And not this forum. My lords, we submit accordingly.
Thank you.
My lord, just a quick, okay. leave, just one point of law. My learned friend in his concluding statement says, our remedy lies in appeal. My Lord, with the greatest respect, without being joined and being a party, we could not exercise the right to appeal.
I have authority to give him. I have authority to give him to go to an appeal. Yes, is there? And I will give it to him. Yes. 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 The authority is there, I'll give it to him.
The court will take a short break. All rise.